Hey everybody, welcome to week 234. And Jack, he has just given us a link that I'm going to put into the chat for y'all because they had breaking news last night. So this is going to go to everybody. And this has to do with Corporate Transparency Act. Crazy stuff. Um, Not super unsurprised about it, but at the same time, I somewhat am. So
Well,
there.
Gary, I would like to just say that our record of prediction is quite solid because if
It
someone wants to
is.
go fact check us on this, I'd like to point out that this is pretty close to exactly what we predicted would happen, which is no enforcement.
And I'm
Look
so
at us
glad that
go.
yeah.
It's like roll back the tape. It'd be cool if we had like such cool video editing skills. We could roll back the tape and say, yeah, here's a clip where we predicted, 2 months ago. The most likely answer is no enforcement. So anyway, I probably need to put my ego in a box now.
We need Ghost Nerdly to be able to play it back
Yeah.
for us. Thanks, Rush. But
Yeah.
yeah, you're right. We did. And as non-compliant as I am in some things, I'm extremely compliant in anything dealing with the law and regulations. So I dutifully spent more money than I should have with my attorney to make sure that my LLC was dutifully filed on time way back when. And then we had to do the same thing for our stupid homeowners association. And I was like, oh, you got to be kidding. But I did it. And so it's out there somewhere, but it looks like we may not need to do it. Is that right, Jack?
Yeah, so interestingly, I my message to my colleagues internally yesterday afternoon into the evening was, well, the procrastinators have won the day. And those who have decided that they weren't going to do anything about it, or either purposefully or just inadvertently, they're like, oh crap, it's the middle of December. So you've gotten a pass. I want to be very clear that it's not a full pass. It is a temporary pass. So may as well go ahead and just talk about what happened since it's, big news. As I told Gary and Adam before we got on live, I'm disappointed in myself that I left my phone in the car downstairs. Otherwise, I was going to play either the CBS or ABC introductory music, the dun 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 dun. So just imagine that in your head for just a moment, and I'll give you like 2 seconds to think about it. Okay, here we go.
Oh, that's good. That's
All
good. I
right.
got it.
So what happened was, and as Adam is saying, that we were predicting this would happen. We were hoping that it would have happened sooner than now, so that people wouldn't have to do what they've been doing, more so over the past 4 to 6 weeks or so. And we've had clients who I have one partner who has filed on behalf of clients like maybe 100, 150 of these things, just as a precautionary measure for his clients. We took a different approach, which here in Charlotte and my corporate group here in Charlotte, which was to tell clients and others that, as we've said on this program, it's easy to do. It doesn't take that much time. You have the information that you need, which is a driver's license or a passport. So, we're happy to help, but I felt guilty charging anyone money for assisting with something that is, easy to do for the most part. Yes, we have clients and maybe some of you have more complex web of corporate structure. So your organizational chart is more complex, and then figuring out who needs to report. But at the end of the day, what has happened is literally at the end of the day yesterday is that a Texas court has said this is unconstitutional, that we believe it may be unconstitutional. So let me make that distinction. They are not ruling on the statute or the regulation. So recall that there has to be a statute that's put out there, and then a regulation that implements it that has the details. So, for example, the details as to who has to do what prior to if you were formed prior to January 2024, if you were formed in 2024, if you're formed in 2025, those specific timelines are in the regulation that is promulgated by the regulatory agency, which is in the executive branch, which is based upon a statute that is promulgated by the legislative branch, so Congress. And so you have to follow this kind of waterfall of statutes and regulation to kind of get to what I believe is the true endpoint of the story. And so the court said, we believe that there are issues. So until we figure this out, we're basically pausing everything. And it is because of the nature of where it was filed, this applies across the United States. So we've talked in the past about sometimes it only applies to the people who actually are part of the lawsuit that are listed as the plaintiffs on that first page of the complaint. In this instance, the court is saying that nobody has to do anything for the most part. And that's a very 30,000-foot level. So let me break that down a little bit. What it means is that if you filed, that's fine. If you haven't filed, you don't have to file at this time. It is possible down the road that the government puts up an argument and the courts, potentially the Supreme Court, which is why I have it in the background, that is the Supreme Court building, by the way, will end up having to deal with, because you have the Fifth Circuit, you have the 10th Circuit. We in the Carolinas are in the Fourth Circuit. So you may have different courts. These are the appeals courts. So you have federal courts, you have appeals courts, then you have the Supreme Court. That the appeals courts may come out differently than on this. And then so the ultimate arbiter is the Supreme Court, and they will have to say yes or no, or say, yeah, you guys need to kick it back down to the federal court to deal with some issues, kind of thing, and interpretation. So what happens is that you don't have to do anything now, but you may have to do something down the road. There is, like I said, another district court that is held similarly, and there are other courts that we believe that generally the legal profession and Politico people believe that will do the same, which is put a stay on it. Because once you have one federal court that does this, it's easy for the other federal judges to say, you know what, we're not going to create an inconsistency with what's going on, so we're just going to rubber stamp the stay and the injunction and everything else. And so there is discussion, and just so you know, if you're interested and you actually read the the what is put out, and as Gary said, I gave him the link and it should be published in there, and it's our kind of summary. One of my partners actually beat me to it. I was in the process of doing it and found out they were doing it, which was great. One more thing off my list of things to do. But what is not clear is those entities, for most of us, that were formed prior to January 1, 2024, and the ones that were formed in 2024, it's not necessarily clear as to, does the injunction apply to them? It focuses on January 2025. I went back yesterday and I, as I said, I tracked through, and then so you have the US code, USC, which is the statute. You have the CFR, Code of Federal Regulations, which is the regulations. And if you track through that, and the opinion says that both the statute and the regulation that enforces it and provides the details are stayed. So to me, anything that is in writing underneath those, those sites is stayed. There has been some discussion as to, well, maybe that's interpreting it a little bit too far. I mean, the words mean what they mean, I think, which is once they say that this entire provision is stayed, then that means anything under it is stayed. And so that is not legal advice. That is my perspective in that. And I believe because of that ambiguity, that if you were to say in this moment, okay, so therefore I'm not going to file anything, that you're probably going to be okay for a couple of reasons. First is that the ambiguity exists, but possibly, and that for them to enforce something when it was ambiguous to begin with is going to be very difficult. Most importantly is that they don't have the financial resources nor the personnel to go chasing after everyone who didn't file because they were under the wrong impression on what they were supposed to do. So there's enough confusion in all of this, I think, to say, okay, you're probably going to be okay if you don't file. Now, others take a different perspective, which is, okay, what's the big deal? I fill out a few lines on a piece of paper. I give the federal government a copy of my driver's license or my passport, a document that's been issued by a state government or a document that's been issued by the federal government. So they have it already. So what's the big deal? So, it's up to all of you how you want to roll with this, but I think you're okay either way. Some people are very, actually yesterday, someone asked me, and it's someone who is very guarded typically with information and doesn't like having their information and their business stuff out there in the public domain. And she said, and I called her and I said, you don't have to do it. And she said, well, I already did it, but it's no big deal. And, so again, I can't predict how people are going to react to this because my predictions would have been incorrect in, 2 or 3 cases of people's personalities on how they deal with confidential information. So long-winded way of saying that big pause. It is not that it's been deemed unconstitutional. I had to respond to someone this morning that said, hey, found out this information. Apparently it's unconstitutional. We don't have to do it. I said, yeah, not exactly correct, but you're part of the way there, so again, just wanted to provide that clarification and, up to you guys what you want to do with it. A lot of people have filed, a lot of people haven't filed, but not because it's purposeful. It's just that, oh my gosh, it's December. So,
Yeah.
so that's
Well,
what that is all about.
that's one less thing to cram into the 3 weeks, not even 3 weeks left. And when we're trying to cram in 5 weeks into that span. So for those who procrastinated, maybe you guys were smarter than I was. But anyway, thank you for that update and the fact that that was not legal advice. That's really good to know coming from an attorney. So thank you. Adam, any besides, hey, I told you so, and let's go back into the archives, boast nerdly. Um, what anything that you would chime in on that or segue to something else? But before we do that, like, what office are you in? Because this is not your office.
Yeah, I am in one of our clients' offices, Greg Harmon, ACO Medical and Atlantic
Ah,
Coast Orthopedic Resources. So, got a meeting here at noon in their conference
okay.
room. So, he was kind enough to allow me to use his office. And if you're, well,
Football
look at all
fan.
those fun helmets on the back. Yeah, if you're a football fan, Greg's your guy. He is a Gamecock, so I'm wondering why he has all those competitive helmets sitting up there. So thanks for chiming in, Alex.
Yeah.
Alex is going to be with me at noon.
All right, cool. Um, one of the things that I thought we would do as part of our grab bag of the 3-part series of what am I missing? What am I forgetting? Which is really easy to do because, isn't it interesting? We come off of Thanksgiving, which was late, and now all of a sudden it's this sprint, like, man, we got year-end planning, we got all kinds of stuff, we got holiday parties, we got all this stuff going on. I mean, it's chaotic. But one of the things that we see frequently in our world is um, people doing some last minute planning or like, oh gosh, what should I be doing on my taxes? Because we're really intentional about making sure that we have multiple meetings throughout the year so that people aren't doing the mad scramble in the last couple of weeks. But people still, a lot of times, even when we've been planning, they have stuff that's come up like, oh, we had a windfall here. Um, what do we do? How do we minimize our taxes, et cetera? So regardless of whether it's our clients or somebody else, something that Oh, Alex, thank you. Yeah, we appreciate your willingness to help host. But one of the questions that I've got for you, Adam, is like, if somebody has not been doing their planning, or what are some things that you think that can be looked at or should be looked at, whether you're with us or not, that you should be pushing your CPA to help you navigate while we still have a little bit of time before 12/31?
Yeah, no, I appreciate the question. So, I thought what we could start with, since we have a three-part series, I'm going to talk really slow and I got to, kill some time so Jack can do the chat GPT search to fact check me on stuff. I'm just kidding with that, right? So, um, I thought it would make sense, at least from a tax perspective, to focus first on what, because there's a lot of stuff with tax planning. It's like, hey, look, it's going to be effective for this tax year, but we can actually decide to do it next year, or you already did it and you just need to go back and do some homework. So I thought that the most important things to hit up front are no, you need to get that crap done before the end of the year because I can't do anything about it if the year's already passed. Um, and there's really uh, two things that um, you have to focus on, uh, and they're both related to pay. So if I'm a business owner, you know, it's critical for me to understand what am I paying myself. And a lot of people that own partnerships or C corporations at this point, yeah, tune it out. That's S corp stuff. Reasonable wage S corp. No, this applies to everybody. So if I'm a C corporation, as an example, you know, old school C corporation before the Tax Cuts and Jobs Act, and Jack and I still share a client that does this, even though we said, hey, you might want to think about a different way to do this, is, hey, I don't want to have to pay tax twice on the money, because C corporation pays tax. And then if I want to get the cash out, I got to pay a dividend on it. And in the old days before the Tax Cuts and Jobs Act, that was terrible because you ended up with like a 50% effective tax rate when it was all said and done. In today's world, oh, nay, nay, because the C corporation tax rate is lower, suddenly there's a little bit more parity between, getting cash out of a C corporation via, not through payroll versus taking a distribution from an S corporation. So, this is where Jack says to his compliance team, hey, man, I didn't say that crap. Boatman said that crap. Don't pin that crap on me. But the, you know, so in a C corporation, like if I've been taking if my plan was, hey, I'm going to bonus out, $500,000 to myself to try to take my C corporation income down to zero, you know, I can't afford to pay it because I don't have any cash. That's ridiculous. You should not do that. And even because you don't need to anymore. The C corporation effective tax rate is 21%. But independent of that, so it's a low tax rate if I wasn't going to take the cash out. But even independent of that, if I was going to take the cash out, but not all of it, like I made a bunch of money, want to leave some in for working capital, or I've got debt and I needed to pay down some debt. So part of my income was cash that is not in the company anymore that I earned, but then paid out to other parties. And my plan was, well, bonus out all the income. That's silly too, because all that I really care about is what cash am I putting in the pocket as an owner and what's the most effective way to get that out. And in a C corporation these days, the most effective way to get it out is a little bit of W-2 and a little bit of a dividend payment. No different than an S corporation. So really then all you're doing is debating how much should be in each bucket, right? And, a good rule of thumb is, you know, 50-50 up until the social security limit. Like you get more aggressive if you wanted to on the dividend side, but 50-50 up until the social security limit, which in round numbers is around 140 some odd $1,000. But beyond that, you got a ton of flexibility. So if you talk about the upper threshold, you know, if you called a recruiter tomorrow and said, "Hey, I'm a private equity firm and I need to find a CEO for a company that I just acquired because we can the founder." This has never happened. You've never heard of this before, Jack, right? We can the founder, he or she sucked, we need a new CEO. What should we expect to pay for them? Their answer would be
It
probably
depends.
probably about 250. What size is the company? 15 million bucks. Probably about 250 with some sort of incentive compensation on the upside, whether it's stock appreciation rights or whatever, right? But the key there is 250, not 500 grand. So I know that we all think that we're worth a lot. We're not. Our replacement value as CEOs of middle market companies really is not a ton, well, to the potential of what we could put on our pocket. Secondly, you know, Adam has been through audits before and he has passed audits where reasonable compensation was deemed to be the social security limit, not 250 grand. So, you kind of, our opinion is, hey, there's really no reason to ever pay yourself more, it, if you don't have other reasons to, you know, on the low side, you know, 50-50. So if I made 200 grand, 100 grand W2, 100 grand dividend payment, you know, up to the social security limit. And at the upper threshold, to do the most Cadillac of Cadillac retirement plans, it's around $330,000. No reason to ever do beyond that. So if you're sitting here thinking, oh crap, why is he bringing this up now? I'm already close to the end of the year. It's because you're close to the end of the year. It's not too late. Like all the time when people have screwed this up or we bring on a client late, um, in the year and they've been screwing it up, you can always go back and amend your payroll tax returns to reflect what you want to have had happened. So it's one of those few times where, because we're in the current year, I can go correct the past. When you go beyond the year and W-2s have already been issued and sent in to the IRS, all is not lost, you know. But at the same time, um, you it's a bad look, to go back and and correct it once you've already sent it to the IRS, versus amending payroll taxes in the current year. So next question that we always get is, well, but I've had a pattern of paying myself $500,000. Isn't that going to raise a red flag? In theory, maybe. Never come up on an audit. So it's one of those. I'd rather I'd rather ask for forgiveness and try to and not win, than not take the chance in the first place, because it's never come up. And I also have precedents on my side of the position that I want to take. In other words, like, there's not been a tax court case to my knowledge, and I've done a lot of research on the subject, where the tax court sided with the IRS in a specific fact pattern called, I paid myself too much money as the owner and now I'm not. Not been it, not as far as I know. Now, Jack could find somebody at Shoemaker that might find somebody in their tax department. Well, actually, Jack, I listened to tape, blah, 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 versus, IRS commissioner, da, da. I've never heard of it. Right. So that would be one to fix immediately, is to look at what you're paying yourself and make sure you are not leaving money on the table from a tax perspective. And a lot of people, oh man, it's just too much effort. What are we really talking about? I mean, on 100 grand, you're talking 15 grand of tax savings. So I don't know. I mean, if you don't want that, I guess more power to you. You're Scrooge McDuck swimming in the money pit. But for me, like, I'm gonna go through a couple hours worth of effort to get me some 15 grand. So anyway, that is item number one.
Hey, time out. We got a question that came in here from WJ, and it says, any thoughts on good and bad of cash balance plans and tax implications and owner advantages?
Yeah. So good question, because that was going to hit the theme of number two, which was, hey, if you're going to have a retirement plan, you need to get yourself a retirement plan set up. So, cash balance plans are the sexiest version of a retirement plan that's available. And I kind of love that that they call them, hey, cash balance plans. At the end of the day, what we're most familiar with is it's basically our dad's pension plan. And the only difference between dad's pension plan and this plan is this plan you actually have to fund. So so the way it operates is, you get together with, an actuary, just like a pension plan would operate, or a whole life policy would operate. You basically say, hey, look, I'm going to retire in 15 years. I'd like that to be 2 million bucks when I retire. You know, what do I need to contribute over the next 5-year period to then meet that obligation based on a projected growth rate of what I'm going to contribute? And they give you a number that you got to contribute every year. So it's fabulous from that perspective. It's the perfect fit for a business that generates pretty significant fairly significant, predictable cash flow. Um, and the owner has, hey, I've already done everything else. So, look, not digging into anybody's lifestyles at all, but generally speaking, you know, if each owner has got, call it above 500 grand in taxable income, nailed it. This is where I would go next. If you're below that, I mean, you can get, 60 grand effectively into a 401k plan with a profit sharing plan, double that if I put my spouse on payroll. So I have a hard time and not have the long-term commitment. Like if I choose to do it 1 year, I can. If I can't do it the next year, I can take it away. So I have a hard time getting on board with recommending these plans for people that are below that kind of 400 to 500 thousand dollars in taxable flow through income perspective. I mean, you could still make it work. It's just I wouldn't do it. So outside of that, I mean, I could get into the theories of, well, hey, we're in an effectively low tax rate right now. You really ought to just pay the tax on the money now and then have it post tax. Like that's all the theory. Like if I'm not going to save money anyway, except for if it's out of sight, out of mind, and I don't care, Adam, I want to stick to the government and not pay tax today, and I've exhausted all other options from a retirement planning standpoint, cash balance plan, absolutely the way to go.
So, before you keep moving on here, Adam, there was one other one. Just to reiterate, Matt asked, so max SEP contributions if cash flow supports it, correct?
Yeah, that's exactly right. Yeah, no reason not to do that if the cash flow supports the decision. And again, it's kind of one of those, you know, I I don't I don't want to be retirement poor, and everybody knows what that means when I say that. Like in other words, like don't be retirement poor, because why, Gary? You do need to, have and save for your future. At the same time, I don't think Social Security is going anywhere, like some of the conspiracy theorists would have you believe. And at the same time, I can't, you know, if my kids don't inherit anything, that's not the end of the world. you know, if I can't I can't take my bank account with me into the grave. You never see a hearse with a U-Haul. I could go through like all the laundry list stuff. So it is irresponsible to not think about your future. At the same time, you know, if my lifestyle was already pretty reasonable, would I make it worse to then save for retirement? Probably not. I'd focus more on making more money so that I can fund what I need to fund.
Jack.
Yes. My turn. I'm tagging Adam out. Time for a
Yeah.
legal issue. All right.
Yeah.
Been thinking been thinking about this.
You were just itching to talk. That was the issue.
Well, this has been on my mind because it just seems like it comes up, and it usually comes up when it's kind of too late, which is into the next year. And so, great kind of initial legal volley for your consideration, which is, and we've said this, I've said this many times before, we've said this many times before. You really need to look over the documents that you have in place, specifically the governance documents, meaning the operating agreement, the shareholders agreement, the bylaws. And for one thing in particular, which is things that are outdated. And the story that I've told before on this program is true story. Four fraternity brothers get together after graduation. Um, some of them go post graduation to get MBAs, but they open up a business together. They're very successful over the course of 20 plus years. One of them, and each of them, they have, I think, three divisions of the business. One of them is not doing as well as he should be. He's been distracted. He has caused losses that are covered up by the revenues of the other divisions. And they're kind of getting tired of it. And the whole, bromance of being fraternity brothers is long gone. So they come to me, the three of them out of the four, and say, what can we do about this? And so my first response is, what do your documents say about it? Now, the answer to that varies from client to client. Sometimes it is, well, we don't know because we don't know where those documents are. Sometimes it is, well, the documents really don't say very much, or we have different owners, or there's been changes that we just haven't documented. In some cases, it is, well, there is a buyout provision in the agreement, a buy sell, and there is a specific formula that says if majority, super majority, whatever it may be, wants to kick someone else out for cause, possibly, or for no reason, then you have, if you have the possibility of doing that, then the formula is set. So in this hypothetical, which is real, they basically came back to me, and they went back, did the calculations, and they came back to me and said, no effing way that we are going to pay that person that amount of money. I said, well, okay. And for what reason are you not going to pay that person that money? Well, it's because we've been already paid him and his family a ton of money through very generous distributions, company car that is a Cadillac, not the Chevy, that is, first class flights, doing all the boondoggles to Vegas for the, the conventions and things like that, and bringing family along with them and those kind of things. And so, it is then, well, you should have maybe considered doing something differently. And all of you, when you were in harmony, acknowledging that that formula would not work and it would be very expensive to buy someone else out. And so my thought is to share is that go back and look at those things that were either relevant at the time and applicable at the time, or that are, that need to be modified because the circumstances have changed. And relatedly is, if you have a buy sell that is paid for via insurance. So imagine the scenario, and now I'm switching gears, I do that, to a different concept, which is that if your document says that the company or the individuals will own a policy and it is $1 million, and that should cover likely 85% of the money that would be paid out to an individual. Let's say if the person passes away, and that's the money that would be used to buy out the interest from the surviving spouse's from the estate, which the surviving spouse may hold those interests momentarily. So then that money gets paid out over the course of time. If you are successful in your business, the value of the business is going to go up. So your 50%, your 25%, your 20% is going to increase. Conversely, the value or the amount of money that is paid out on that insurance policy is not going to cover that 85%. It's going to cover 75%, 70%. It's an inverse proportionality, right? And so you need to be considerate about, or consider those kind of things that, again, are relevant, that are proper calculations at the time, but may have become outdated just from the mere passage of time. And the success. It could be the other way around, which is that the payout is going to bankrupt the company because and the person who is insisting on getting the payout per the formula is now, they have you handcuffed. And so again, consider those kind of things in the documentation, and we'll talk, over the course of time, maybe in the future sessions with more specificity, but those are just some general concepts that I've seen very recently, as meaning that in the past week or so, those specific two issues, which is formulas that are not relevant many years later. Some in the story, the hypothetical was actually about 22, 23 years later. And then having the funding for a buyout not cover as much as originally intended, so that there is more money that has to come out of other places, whether it is operating capital, whether it's an SBA loan, whether it is seller financing. So again, I'll stop there.
An ounce of prevention is worth a pound of cure. Pay me now or pay me later, right? And the later it
Absolutely.
goes, sometimes those are some painful lessons. So pay attention. All right, I'm kicking it back over to you, Adam.
Yeah.
Go ahead.
So item number two, they kind of went with the leading question on the cash balance plan. Item number two, I want to get this dialed in before the end of the year, is what do I want to contribute to my retirement account? So, if someone on the call is like, but I don't even have a company retirement account established, it's like, your options are a little bit more limited in that scenario at this time of the year, based on whether you have employees or whether you don't have employees. Um, but if you do already have a plan, you know, what you would want to do is, dust it off and say, okay, what do we want to do, into the retirement plan? Because, most people, when they set up a 401k plan, they usually will go ahead and set it up with a profit sharing match component, that's discretionary, that you can calculate every year, and then most people just don't use it. But in certain situations, that can lead to, a pretty good owner benefit with a minimum um, match requirement on the employee base. So based on, our experience, the way a profit sharing plan will work is that I can pay the owner of the company, 25% of his or her pay as a profit sharing bonus. Now I have to do something for the other employees, but generally those that are not considered highly compensated executives with some other certain provisions associated with it, that match component might be like an extra 2 or 3%. It's not a ton, when it all shakes out on the math. So you want to run your scenarios, and a lot of retirement planning companies like, well, we need to have the end of the year done before we can do the blah blah. It's bullshit. Sorry about the language. Didn't mean to do that. Shoemaker compliance is like, edit that. Just kidding. Um, you want to know what you're going to contribute and what's possible before the end of the year, because again, it's going to impact what you pay yourself. So for example, if I'm like, look, I want to turbocharge that and max that thing out, and I've been clocking my W2 at around 200 grand, the answer is I can't max it out unless I take my W-2 up in the 300 plus range. So I want, and I got to do that before the end of the year. So if it's like, well, I'll tell you what you can contribute after the end of the year, it's like, well, you're too late. You know, I need to know that before the end of the year so I can get my W-2 dialed in. So that's really the second um critical item is, if I don't have a plan, look to see what kind of plan that I can establish before the end of the year. And again, your options a little bit limited, but there are some. But if I already have a plan, figuring out what I want to contribute into it so I can get my own W-2. If I've got a spouse on payroll, get spouse's W-2 dialed in to maximize that contribution to the extent that I want to, and also feel comfortable with what I'll have to do from an employee matching perspective.
Am I up?
You're up unless there are any questions that want to interject themselves, but let's go ahead and go legal next.
All right. So number two on my list is, and now I'm moving towards actual contracts that you have in the business, that you are a contracting party, and they have terms and conditions and a stated term in the agreement. This time of year, many times a lot of contracts will be keyed off of end of year, actually a fiscal year, calendar year. And then they will say, I mean, in some cases, it may be already too late because we're only a few weeks into, to the end of the year. But sometimes it is, it is what's called an evergreen provision, and meaning that, I mean, well, the I don't know the source or the origin of the term, but I could imagine, okay, an actual evergreen tree always staying green until something else happens, or evergreen meaning it stays green until like green light kind of thing moving forward. So in either case, it is that if you don't do something like terminate the contract, then it automatically renews for whatever period of time it says it's going to renew. So it could be a month, it could be a quarter, it could be an entire year that you're obligated to do that. So it's a window of time that you have the opportunity to say, yeah, done with it, moving on. And if you don't, then it moves on with you in the contract, and you don't have an opportunity to cancel that contract until the following renewal period time, or potentially for cause. And so, be mindful of those timing issues, that you're not wrapped up into another year in a relationship, or 6 months in a relationship, thinking that you can get out of it. A lot of times just kind of forget. And, I would say, just as a general practice, and this is your free legal guidance, specifically, that when you enter into a contract and it has timing provisions in it, now I would say most of us, if not all of us, or I dare say very close to all of us, use some sort of electronic calendar. And so it's easy to go ahead and put that on a calendar, and then have a 2-week, 3-week, 1-month reminder that you have to do something with a contract moving forward, so you don't trip over or cross over that line of when you're supposed to provide notification to cancel a contract. There's also the provision, the reverse of that, which is that unless there is a formal extension, then the contract terminates. And yes, there is a concept called course of performance, course of dealing, which would be, let's say, for example, contract ends naturally at the end of this year in a few weeks, and both parties continue performing their side of the contract, let's say through summertime. And then the other side comes to you and says, haha, we're done because you didn't, we extended the contract, but we didn't have terms and conditions, or we don't owe you that amount, or we're going to pay you whatever. There is the concept of, well, by your behavior, you have extended the contract along the terms and conditions that were in existence from the written contract. I would not rely upon that, because that is an equitable argument, not a necessary legal document argument. So be mindful of, again, those dates, those triggers that would say, unless you provide 30 days written notice that you want to extend the contract is terminated, or may be terminated, or becomes a month to month, whereas it was a 1 year term. That becomes a very dangerous and expensive issue when you have the other side does come to you and say, okay, we're in the extended period, we're in overtime, and we don't need to provide you notice, but we're going to provide you notice, and we're going to give you 30 days. And whatever it is, the contract basis is, or what is being performed, the wind down time and the wind up time to find a different service provider may be more than 30 days. And so you have to think about those contingency plans as far as, what are you going to do if there's a relational divorce in this contract, and you need more runway to be able to find a new vendor. And again, the flip side of that is, what if you're the one that's providing the services, and now all of a sudden your best customer decides, hey, we're out? You would want runway to be able to fill that capacity with a new customer, maybe ramp up your business development, your marketing, to be able to fill that gap that may be created by a company that is providing, 50% of your revenue, maybe. That is dangerous in and of itself, to be so client centric. And I'm sure that the back of Adam's neck hairs are raising as I say, 50% concentration with one client or one customer. But so that would be kind of my number two thing, which is be aware of the timing within your contracts, whether you're the recipient of services or the provider of services, or provider of goods or recipient of goods.
Concentration risk is a real deal. But real quick story, we invested in a company here in town when I was in Ohio, and over 50% of their client base was tied up in one client, the Home Depot. And we were like, man, you got to diversify. That's really worrisome. But they sold to the Home Depot, a great strategic acquisition, and I think for $265 million. So, like, that is one where we were very worried about it, and rightfully so. But it made a perfect strategic partner, and it's been really a very good marriage, actually. So anyway, but that's the only time that I know of where that concentration risk actually worked out well in a strategic acquisition like that. But anyway,
Yeah, I would say
Adam,
that's probably in the minority of cases, because a lot of times those, and again, not to disparage Home Depot, Lowe's, Walmart, any of those, but a lot of times I've seen where they learn how to do what you do as a goods and services
yeah,
provider and just start doing it themselves. They terminate the contract and start doing it. And there's no way that a vendor up against Home Depot or Lowe's or Walmart is going to, or Target is going to negotiate a non-compete within that contract. And so, that's again, the risk, one of the risks
yeah,
in the
you're right.
concentration risk is that who you're providing it to is going to learn it and do it themselves once so you have to be able to easily, not, I shouldn't say easily, you need to be able and mindful of replacing clients that are larger in the concentration. My 2 cents.
Oh, Papa Joe just weighed in here. Good to see you here, Joe. It's not just concentration risk on the customer and revenue side. It's also a problem if your supplier concentration is focused primarily on one supplier. That can be very true as well. Great point, Joe. Thank you. Got another thing that has come in here. Is there ever an advantage to pay cash to employees for unused vacation accruals?
By cash, I'm assuming we're not talking cash under the table. We're
Under the
talking,
table.
through
Yeah.
payroll. So Jack, that'll make your compliance people happy, by the way. He's talking about legit. Um, that Bruce, that's one of those things where it kind of depends on what your PTO policy is. If your PTO policy is, hey, I've got a carryover and it's payable upon separation, then it's kind of, you're kind of neutral on the subject. One is, I'm either going to pay them for vacation they haven't used today, or I'm going to pay them for vacation they haven't used in the future. So it becomes a little bit more of a time value of money. How's that going to be make people feel, all that kind of stuff. What does typically happen is that if I change the policy, meaning like, hey, you can carry it forward and you can have it upon separation. And then I say, I want to stop doing that, or I want to go to unlimited or whatever. Then you're probably, even though you don't have a legal requirement to keep the goodwill, you're probably going to need to pay it, out at that point if you have a change in the policy. But outside of that, it's six of one, half dozen the other. You can either pay it today or you can pay it upon separation if that's how your policy reads. Either way, it's tax deduction.
Here's another timely question from WJ. If the tax on tips is erased, a big if, who knows, how could I tip my employees and stay inside the rules? Maybe tips versus a bonus?
Um, so good question. I think that I, while somebody probably will say, hey, let's get creative. And hey, if you get, Gary, you did a really good tax return. Here's your tip. you know, I find it, I don't know. I mean, I could always stand corrected, but the rules around tips and tip reporting are pretty specific to specific industries. Everybody else just falls in, hey, it's a bonus and it's reportable compensation. So, and even then, interesting fun fact, there is a thing called the FICA tip credit, which is basically an incentive to have employers get employees to claim tips. So by doing so, you can get a credit for the employer portion of the Social Security taxes that you pay on their behalf by getting them to report. Um, that only applies to restaurants. Doesn't apply to car washes, doesn't apply to hair salons, doesn't apply to um massage the nice massage places, not the bad massage places, Jack. Um, it so I was like, how am I gonna say this? Yeah, yeah. Places where you would normally tip that are not restaurants. It doesn't apply to any of those. So this is one of those where I feel like it was sort of like fantasy land that something was going to happen with this. So I wouldn't, on that question, it's not that it's a silly question. It's just that, look, if it passes, and I think that's a really, 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 really big if. But if it were to pass, I'd suspect that somebody's gonna wake up and say, and this only applies to certain NAICS codes, not the world writ large.
Yeah, and I think that there's sufficient opposition already and concerns about abuses on that. So, you may have experience where, like for example, renting a car, a limousine for an evening, and the tip is embedded into the cost of what you're paying to, rather than giving a cash tip to the driver himself or herself. And so there seems to be a concern about, okay, now pushing, let's say it was $200 an hour tip inclusive, that taking that 20 let's do 220, so that way it's easy, right? Okay, 20%. So instead of the $20 being the tip at 220, then you increase the tip amount and then it falls under tip, but it's really for providing the core services and it's not really what the driver is going to get as a tip. So that's why I think those kind of scenarios are also on people's minds as to the abuses of putting more core compensate or payment for the core services and shifting it to tip so that it would fall under the exemptions for taxes and things like that. So that's what I've heard on the grapevine.
So guys, I'm going to do a last call because I don't think we're going to be able to have time to get into another subject, given that we have less than 3 minutes. So open mic or open question for anybody that's still on here. We had a nice crowd today, by the way. 36 people were on here at our high water mark, so that's great. Thank you again for Derek that allowed you to be in his office, Adam?
Greg, but yes.
Oh, okay, gotcha. So thank you, Greg. And is that a Tennessee Titans football helmet up there? Like I'm trying to see it.
No, he's all, he's all SEC. Like it looks like he's got all the SEC helmets
Oh
from what
yeah,
I'm
I
looking
see
at.
I see the
Yeah.
UK up there in the back. So
Yeah.
Yeah, let's not talk about that. The whole basketball SEC ACC thing is not going very well for the ACC the past couple of days. So
no,
yeah,
no. Oh hey, hold on here. A couple more. Let's see. Trivia. What does TIPS stand for from a
To ensure
history?
prompt service.
do I have
Ah,
to give you a coffee card now for that too?
I think
Copy,
so.
baby. Yeah, there you go.
And WJ is a Tigers fan.
Yeah, that's right.
All right, that's good. Is it Clemson or Auburn? That's the question. Or LSU.
Hmm.
uh, who knows? Okay, Clemson.
Yeah, yeah. Y'all had a bad weekend.
Yeah.
I don't know who won the Duke game last night, but for a moment I was cheering for Duke, and then I came to my senses just because of the whole ACC SEC thing, and then I was like, yeah, no, not doing it.
Yeah.
So,
Okay. All right, guys. Well, we're going to sign off. Thank you, everybody, for joining it. We'll be up on the BGW CPA YouTube channel later on this afternoon for anybody that wants a replay or came on late. Same way with Santaniello. They have a shoemaker YouTube channel. So thank you, Jack. It's always good to see you. Same way with Adam. And enjoy your meeting today, Adam.
All right.
See you all.
Awesome. Thanks, guys.
All right.
All right.
Bye-bye.
thank you.